Assalamu alaikum and welcome to the Free Legal Advice Show on British Muslim TV. My name is Riffat Hussain and I am your host this evening. As always, you can participate in this show by ringing into the studio and presenting your question to me and the situation that you find yourself in, and I will then address your questions. Alternatively, if you prefer not to ring directly into the studio but still want to put a question to me, you can do so through our WhatsApp group or our social media outlets, and I will get through that for you. As you are aware by now, these programs do get very busy. I do get a lot of questions and it's not always possible for me to get through all of them. If you are wanting your question answered, then please do so as early as possible, providing as much information you can so that I can address the query for you as quickly and as efficiently as possible. You can present any questions that you have relating to any field of law. It could be immigration, it could be criminal law, employment law, family law, as long as it's within the jurisdiction of England and Wales, as that's the jurisdiction I have experience of and I practice in. If your query is something that I can't address, then I may refer you to another service where you will receive the appropriate help for your dilemma. So moving on, I'm going to start, as I always do, with some updates, and there are lots of them this week. The Home Office issued, the UK Home Office issued a statement of change at the back end of last week, some 200 and more pages of that. There's new categories that have been introduced. There are old categories which have been further developed and some changes made to those. Now, the particular focus that I have today is the changes that will come through on the family and private life rules. Excuse me. Now, these are rules that I've spoken about extensively in previous programs. They're rules that relate to individuals who are in the United Kingdom, generally without any kind of lawful status, and are now either married to a British citizen or have British children or children who were then born in the United Kingdom and have been residing here for a period of 7 years. And that is where the most significant of changes in this statement arise. So we are approaching, as many of you may know, we are approaching the anniversary of these rules, the 10-year anniversary of these rules actually being introduced. And the first cohort of applicants who applied under the 10-year route will now be coming to a point where they are achieving settlement. These rules amend the relevant paragraphs in the immigration rules, and they do so in this way. So the individuals who are on the 10-year route continue on that route. There are no changes there. And there are various different examples and scenarios. And those of you who follow my practice blogs will have more information about these. So if I don't get through anything today, you don't get your question answered, and do have further queries, then you may want to look that up or save a question for another show and come through to me at that point. There are 4 grounds, and there have always been 4 grounds under these rules for an individual who can apply under their private and family life. And generally they are, the first one being a child who has been resident in the UK for at least 7 years, and a child who cannot then reasonably be expected to leave the United Kingdom. So it's not an automatic grant of status. There is the 7 years residence, but then in addition to that, the applicant will need to demonstrate that it is unreasonable for them to leave the United Kingdom and reside elsewhere. And that we know as the 7-year child policy, and that's how it's most often referred. There is also those individuals who are aged between 18 years and 24 years, but they have spent at least half of their life in the United Kingdom. So these will be children who arrived at a very young age, have resided more than half of their life in the UK, and are now between the ages of 18 and 24. This category would apply to those. There are those adults who have been residing in the United Kingdom for over 20 years and can evidence that, and those who are going to face very significant obstacles to integration if they leave and return to their own country. So they're broadly the 4 categories. Before I go on to explain the remainder of the changes, we do have a caller on the line, so inshallah I will take that call. Hello, assalamu alaikum. Hello, assalamu alaikum. We appear to have lost our caller, so I will carry on with the information that I was providing. Inshallah, our brother or sister can try and reconnect, and I will take that call from them. So, so applicants up until this point who have been making an application based on their private and family life have been granted 30 months leave to remain, but usually on a 10-year route to settlement. Now, the amendments to these rules will allow successful applicants on the private life grounds to be granted permission to either apply, to choose to either apply for the 30 months leave, which would be 2.5 years, or under the 60 months leave, which would be 5 years. And they can apply for that from the outset, rather than having to apply for 2.5, then an extension, and then applying for indefinite leave to remain, or to continue on the 10-year route, applying for extensions every 2.5 years. There will be application fees, and naturally the application fee for the 60-month application will be higher than the one for the 30-month application. But the significant change here is that those applicants applying under private life rules would need to wait the 10 years before they achieved indefinite leave to remain. The rules will now be amended, and children who are born in the United Kingdom can apply for indefinite leave to remain immediately after spending 7 years of their life in the United Kingdom. And that includes children who have never had any form of status in the UK. So it's a welcome step, because it stops children from having this precarious status where they achieve 7 years, and then the Home Office, as is the system now, because these changes haven't yet come in force, but the child would then need to wait another 10 years before they were able to attain settled status to apply for their indefinite leave to remain. Although the Home Office has made these changes, and these are quite welcome changes, particularly for young children and to give them that certainty, these are not straightforward applications, and therefore anybody wanting to take advantage of these rules is strongly advised to seek independent legal advice and assistance, because there is case law around this. And as I say, there can be complications, and there are ways for the Home Office not to grant that status. Now, that's for children who are born in the United Kingdom. So at the point that they turn 7 years and have been residing in the UK, they can apply for indefinite leave to remain immediately. For children who are not born in the United Kingdom but have resided here for 7 years, there is an accelerated route to settlement. And so they can apply for indefinite leave to remain after 5 years, as opposed to the 10 years that they would do ordinarily. And this almost replicates, if you remember, a few months ago, I explained another change that the Home Office had introduced, and that was about the accelerated indefinite leave to remain for young adults who did have lawful status in the UK. And this brings that into the rules and lowers the age threshold, so it's still from 7 years. For everyone else on the private life route, you would still need to complete the 10 years route before you are able to apply for indefinite leave to remain. And again, if you refer to some of my previous updates, then you will know that there are ways around that. There's ways to reduce that. And so forth. So these are the updated rules for you to take advantage of, and they can apply in many different scenarios. Now, in terms of the date that these rules come into force, so bear in mind I said they're not in force at the moment. They will be in force for applications made on or after the 20th of June this year. So we're around 3 months away from these rules applying. Any applications made before that date will fall under the current rules, and therefore you will end up, or your child will end up, on the 10-year route. So again, please seek advice. Do not be hasty, and make sure that you are making the most appropriate application for your circumstances, and for the best outcome for you and your family. So that's where we are in terms of updates. As I say, there's a lot more. It's over 200 pages of changes. There are changes in terms of business immigration categories. There are new categories that have been introduced. There are some categories which have been amended. And so they're far too vast for me to be able to cover all of them today. We do have a caller on the line, so inshallah I will proceed to take that call. Hello, assalamu alaikum. Hello, assalamu alaikum. I do apologize. I believe that call has dropped. We do seem to be having some technical difficulties with connecting this call, but we will try and get to our brother or sister who is trying to present their question. But in the meantime, I will continue with answering the questions that you're sending through, and also providing you with more information on how to access these routes and how to best secure your legal position. So a lot of the information that I do provide is guidance, and I can't cover every situation and every scenario. And so it is important that you are seeking individualized advice for your particular circumstances. Just as you wouldn't go to the doctor for a prescription because you've got a stomachache and have the same prescription as your friend, likewise legal advice has to be individual to those circumstances that you have. Inshallah, we will be proceeding to a short break. When I get back, I will proceed to answer more questions and provide you with some further information. Join me on the other side of this short break. Thank you very much. Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. I am your host, Riffat Hussain. Thank you for joining us this evening. This is the final Free Legal Advice Show for myself until after Ramadan and Eid. So please do get your questions in to allow me to get through them and answer your queries this evening before we break up for the Ramadan and Eid break. So as I was explaining, the changes in the immigration rules, quite significant and quite far-fetching. But the example that I've given specifically this evening is that of private and family life, because that is where most of our queries come from. That is the information that most people request. And it's now the quickest way for your child to secure status in the United Kingdom, and then by virtue of that for you to acquire status if you are an overstayer with children in the United Kingdom. And as I was just saying prior to the break, it is important that you are seeking individual legal advice, because there is no one glove fits all. It is individualized. Your circumstances, although on the surface may appear to be identical or the same as somebody else's, there may be things in your immigration history, in your circumstances, that are not identical from a legal point of view. And if you have that tailor-made advice, you can ensure a more successful application, a quicker route to settlement, if that's applicable in your case. And so do try and seek that, and do have that guidance behind you. So, and please do just keep your questions coming through. I will try and get through as many of them as I can do this evening. So just picking up on the questions that we have. So we have a question on, and I think this question has been presented previously, about wills and the distribution of property. Under English law, you are welcome to make a will as you please. So there is no distribution of you must leave X amount to this family member. And so if you choose to leave the 100% of your wealth to the family pet, then you are welcome to do that. In terms of your Islamic duties, then that is a question that you will need to ask a scholar and somebody who is qualified to give that advice. But certainly in English legal terms, you can distribute your wealth in the way that you wish to do so, and you do that by making a will. If you don't have a will, and if an individual passes away and there is no will, then that property goes into an estate, and then it would be the government that would decide, or the estate that would be deciding how that's distributed and in what portions. So that's the answer there. We have a family law question in respect of partners, and the question is about divorce proceedings and how divorce proceedings are initiated. And again, there seems to be a theme here. There isn't legal aid assistance available in family law proceedings. They are proceedings that need to be paid for, and can be quite expensive, and most people find them to be out of reach, particularly where there are difficult circumstances to that marriage breaking down. If there's domestic abuse, if there's coercive control, it can be quite difficult to try and rebuild your life, and then also trying to initiate legal proceedings and pay for legal advice. What I would suggest, if you do find yourself in those circumstances, is that the county courts are very helpful and can provide some information, although they can't give legal advice. But in terms of what forms you need, how to submit those forms, advice of that nature, the county court is helpful. And so you may wish to contact your county court, your local county court, and ask them which forms are required, where to submit them, whether or not there are any fees applicable, and how those would be paid. There's also fee remissions. So if anybody's in financial difficulty, then you may apply for a fee remission, in which case you may be exempt from paying that fee. Alternatively, you might want to ask the Citizens Advice Bureau. They do have advisors who can provide guidance, even if it's just to fill in a form that you have acquired yourself. They might be able to assist you in sending that to a court as well. So there are ways around it. It's not really a substitute for legal advice, but if it is something that you are needing to do urgently and can't afford to do it, then Citizens Advice Bureau for some legal guidance, and the county courts for some practical guidance is where you would be advised to go. Moving on from that, we have a question in relation to a business partnership. And the question is this. So my former partner and I were in we started a business together. It was an abusive relationship, and that marriage has now ended. The partner is seeking, or the ex-partner and the business partner is seeking to now sell the entire business. And the questioner is wanting to know what their legal position is. The first point is whether or not there is a partnership agreement. That would be your starting point. Do you have an agreement in writing to confirm that you are in a partnership? If it is a registered company, you can check on Companies House as to who's got what role within that business. But any agreement that you have, and hopefully this is a written agreement, then that is where your starting point is, because you will both be bound by those terms and conditions. But if you are partners, whether it's equal partners with 50% shares in the business each, or whether with different distributions, so you may have 25%, the other individual may have 75%, the business partner is only able to sell their share of the business, not the entire business. But as I say, best place to check is your partnership agreement. What are the terms in there? What are you each bound by in terms of your obligations and liabilities? And then do seek legal advice. Partnership agreements can be very complex. They're difficult to navigate. They're quite clearly emotionally charged, and there's a lot vested in those. So do get the guidance that you need, but do check your agreement as well, and take it from there in respect of what your rights are. So just looking through some more questions. Do excuse me whilst I try and pick these up, because they do come through quite quickly, and so trying to follow the chain can sometimes get rather confusing. We do get this question quite frequently, and I will address this in this way. So the question is, what documents do I require to invite my spouse to the United Kingdom? And I've touched upon this in some of my previous shows as well. There are some general documents. You know, you're required to show that this is a genuine partner. So if it is a husband or a wife, you'll have a marriage certificate. I explained that that marriage certificate needs to be valid for the country where the marriage took place. It needs to be the only marriage. The UK does not recognise polygamous marriages, so you can't have more than one wife or husband in the United Kingdom. Evidence that the parties have also met is important. There's some basic documents that you can produce: your English language certificate, the TB certificate if you come from a country where that's required, evidence of finances such as wage slips, bank statements, etc. But again, I come back to the point I make earlier, that you do need individual advice. If it was as simple as providing a list of basic documents, then everybody would be able to go ahead and make these applications, and we wouldn't have the refusals that we do get. And often in private practice, what I do find a lot of, unfortunately, is individuals having attempted that application that does leave a record on the Home Office's systems. When it's gone wrong, and then they need a lawyer to put it right. And to put something right is more difficult than getting it right in the first place. And you save more money. I know it can seem daunting, it can seem expensive to get that legal advice initially, but trust me, it will be a lot more expensive to get the solicitor to put the problem right for you once it arises. Because what you've then created already is issues on the Home Office file, and they don't erase them simply because the application is refused. The next application that you make not only has to then meet the requirements, it also needs to address the issues that have arisen. So, for example, if the Home Office concludes in the initial application that the marriage isn't genuine, or the marriage isn't subsisting, i.e. there's no intention of the husband and wife to live together, the likelihood is that they will refuse the application, the second application, on the same basis, because they don't think that there is a genuine marriage. And so the level at which you need to then provide evidence is far higher, because you firstly need to bring the Home Office to the neutral ground where you've established that there is a genuine marriage, and then you need to build on that and provide the evidence for why this marriage is genuine. So you're starting off further down than you would have been in the initial. You lose a lot of time. These types of appeals are taking in excess of 18 months to get to tribunals. And the cost of appeals in terms of your lawyer fees and preparation are quite high naturally, because there's a lot of work that needs to be done to remedy the problems that have been created. So please never be shy of seeking that legal advice. Getting it right the first time, it will save you a lot of heartache and a lot of financial and time expense. So try and follow that through. Just moving on to another question. So the question is, Assalamu alaikum, I want to know, I had to submit my application in June last year, but didn't hear anything about, so what should I do? Because I'm just sitting, nothing the Home Office side, and is that possible that I can get travel document or something like that for traveling abroad and can come back to the UK then? So in terms of that question, I don't know what application has been submitted to the Home Office and what your current status is, but inshallah we are about to proceed to another break. I will start answering your question because I'll then have to cut that off before I come back to it, and that will just create more confusion for you. Whilst we do go to this break, if you can just send some more information through, such as what your current status is, what application you made, and then I will address your question as soon as I get back. Inshallah, join me then. Thank you very much. Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. I am your host, Riffat Hussain, and we've now entered the penultimate segment of this show. Just before we went to the break, I did read out a question. I will wait for our brother or sister to send the additional information through, because I have insufficient details to answer your question at this stage. I will move on instead to another question that has been sent through, and that is this. My friend is an overstayer and in a relationship with an Italian national who has pre-settled status. Can he make an application under the immigration rules? Can they marry as well? So, with regards to the Italian national, so the question relates to the UK immigration system. And as many of our viewers will be aware, that there were some transitional arrangements and rules for European nationals who were in the United Kingdom prior to us leaving the European Union. And they either currently have pre-settled status for individuals who hadn't been resident in the United Kingdom for a 5-year period, and settled status for individuals who had. Now, the questioner asks about a friend who's in a relationship with an Italian national with pre-settled status. The friend themselves has no status. They're an overstayer in the United Kingdom. Can they make an application under the immigration rules, and can they marry as well? They can marry. In order to marry, they will need to seek permission from the Home Office and also give notice. So in terms of applying for permission to marry, just be aware, obviously the Home Office is then alerted to the fact that you are an overstayer. They generally, in those kind of situations, will question whether or not this is a genuine relationship, whether this marriage is a genuine marriage or whether it's a sham marriage, in order to enable an individual who has overstayed in the UK to then regularise their status. So there will be scrutiny there. The Home Office may invite you for interviews, and then generally what they do is interview each partner individually, ask some general questions that they would expect couples to know about each other, and then reach a conclusion as to whether or not this is a genuine or a sham marriage. And then if you do meet the requirements of the immigration rules, then you can absolutely make an application under the immigration rules. Now, there are two types of applications here. So there is the application if you do get married, but there's also an unmarried partner route. And I don't know the circumstances of these individuals, but it does say that they're in a relationship. But if you are able to show that the individuals have been in a relationship for a period of 2 years, and they can demonstrate that this is a genuine relationship, they have been in this relationship for a period of 2 years, then they will be able to apply under the immigration rules as unmarried partners as well. So it may be that they have an Islamic marriage, which isn't recognised as a legal marriage in the United Kingdom. They may have been living together for a period of 2 years. However, for the purposes of English law, they are unmarried partners because that marriage isn't recognised. But the fact that there is a nikah certificate, that they have committed to each other in that way, may be of assistance to that application. That doesn't mean that the Home Office will accept at face value that this is a genuine marriage, but it may go to assist towards that. So that there are two routes: the unmarried partner route, where there's no need to get married prior to the application being submitted to the Home Office, or there is the marriage route, but then that you would need to contact the Home Office for permission to marry before you are able to get married, and that in itself can cause problems for you. So that's the position that you're in. So just moving to another question. forgive me, just scrolling back up. So we had this question last week as well, and it's the timeliness of applications. So the question that the individual asks is about an application that was submitted late to the Home Office, and this application was submitted over 14 days after the original permission to leave expired. So the individual had overstayed for more than 14 days and then submitted an application to the Home Office. Now, unfortunately, the effect of that is that you then lose the continuity, or you break the continuity of your residence in the UK. The Home Office will disregard up to 14 days. So they will regard 10 days, 11 days, 12 days, 13 and 14 days. Anything beyond that makes you an overstayer. The continuity of your status breaks. And this is really, really important because, again, a lot of people don't understand, for the purpose of UK immigration law, getting it wrong has very serious consequences. If you have been resident in the United Kingdom, excuse me, if you have been resident lawfully in the United Kingdom for 9.5 years, and you just need another 6 months to achieve that continuity, and you get it wrong, you effectively lose that 9.5 years and you start from day one again. And this is where it's really, really important that you protect yourself, you understand your position, you understand your legal position, and do seek that help. It may seem that you're able to do this, but the rules are deceptively quite complicated. They can seem simple, but there is a lot of guidance and information behind there as well, that if you're not aware of, things can go wrong quite quickly. So anything beyond 14 days breaks the continuation, and then you are starting afresh. And it doesn't matter how long you've then been in the UK, and how long you've had lawful residence, or how many taxes you've paid, or how long you've worked here. None of that is taken into consideration. The rules are absolutely clear. Anything beyond 14 days breaks continuity. There is an exception or two. One of the exceptions I touched on last week, and that is for the period between January and August 2020. The Home Office will disregard that period if you can demonstrate that you were unable to access legal services or submit the application due to the COVID pandemic and the ensuing lockdowns. So there are, as I say, ways around it, but just be careful as to what it is that you're doing. Always be aware of your deadlines. Seek early help. That's the key as well. Don't wait till the day before or the week before to ring a solicitor and try and get an appointment, because the chances are you're not going to get one. And then you may become an overstayer. So somebody's just put in a follow-up question in response to that. How strict is the 14-day rule for making a late further leave to remain application? What if I'm late by 1 day, i.e. the application where it was made on the 15th day? It doesn't matter. You can be late by 1 minute. As long as you go over that 14 days, you've broken the continuity. So it could be a minute, it could be an hour, it could be a day. It has exactly the same effect. And I know that's not the advice people want to hear, but that's how the rules are interpreted. And it won't be overlooked, unfortunately. That's the difficulty. So just be careful there in terms of how you make those applications and the timeliness of those applications as well. So with regards to the previous question of the overstayer in a relationship with an Italian national, can he make an application under the family and private life rules? Yes. So the unmarried partner is the family life rules. So yes, they can, as long as they meet the eligibility criteria. And so yes, absolutely. But again, it would depend on their circumstances and what category they do meet. We've got some follow-up questions here, and again, do excuse me because they don't always come through in order. So I believe this relates to the questioner who was asking earlier about having made an application in June last year, and that they've been waiting, and they're wondering if they can go overseas and come, or if they can have a travel document and go overseas and then come back. If the question is that you applied for a spouse dependent visa, family route spouse visa, the question is no, you can't, unfortunately. If you do leave the United Kingdom, your application will be withdrawn. The Home Office will have your travel document, your passport, in any event, and therefore, if they return that, the application will be withdrawn. There's only very few exceptions where they will return the passport without withdrawing or cancelling the application itself, and that generally would be where it's a genuine family emergency, and you do need to travel for that medical family emergency. I've not really seen many examples outside of that where an individual is permitted to go overseas. If you have been waiting over 12 months for this application to be processed, you may want to start taking some steps in order to chase a decision. Again, as I said last week when I went through the Home Office processing times, for family applications, the Home Office is giving an indicative time of up to 10 months. And so you've been waiting a lot longer than that. So again, it may be that you need somebody to chase that for you, start making complaints, start finding out what the delay is. Inshallah, join me on the other side of this break, and I will continue to answer your questions. Thank you very much. Assalamu alaikum and welcome back to the final part of the Legal Advice Show on British Muslim TV. I am your host, Riffat Hussain. As we enter this final segment, I have a few more questions just to go through. Please do send your questions through. This is your final chance if you want an answer. I will be back now after Ramadan and Eid, so that there will be quite a long break between now and the next show. So I have some further questions. So one of the questions asked, do I need to submit my marriage certificate and all the other documents previously submitted in every further leave to remain application? And the answer is yes. You need to support each application every time you submit it. There may be certain documents that don't need to be submitted. So for example, if you have previously submitted a valid English language certificate, then you don't need to submit that, but you are required to meet the eligibility criteria for the application, and therefore it is advisable that you do resubmit any supporting evidence and then update that evidence to show the change and the development in your relationship between your last grant of status and then your current grant of status as well. Your circumstances may have changed, and more importantly, the rules and the evidential requirements may have changed. So please do check that. Just because you were granted status 2.5 years ago on a particular set of documents doesn't mean that if you submit the same again, you'll be granted over again. So again, be careful. Do not fall into that trap. I have a next question. I have lawfully stayed in the UK for 30 months on the 10-year route. I have an 11-year-old child and live with my husband. We have passed the English language and meet the financial requirements. What is my best option for the next application? Now, you may have watched last week's program where I went into quite a lot of detail with regards to these applications. If you are coming up to renewing your further leave to remain and you are on the 10-year route, you can vary the application now into the 5-year category. And what that basically means is you are swapping categories. It's not necessarily It's not the fact that they will simply change it. You do need to ask to vary the application. And so you're going from the 10-year category and asking to be moved into the 5-year category. If you are successful in doing that, then you will be moved into the 5-year category, and that 5 years starts afresh. So it's not an add-on to your 10 years. You start the 5-year afresh from day one. You've then got 5 years to complete. The advantage of that is if you do that at this stage, at your first extension stage, then you've done 2.5 years, you do another 5 years, and then you apply for indefinite leave to remain at the 7.5-year point. Whereas otherwise, if you just extend and simply extend into the 10-year route, you will then need to complete the full 10 years before you achieve settlement. So you essentially shave off 2.5 years worth of leave and the need for that extra extension at this stage and achieve that early settlement. So yes, English language to the required level, which would be the A2 for the in-country application and the financial requirements. And please do ensure that the English language is from an approved provider. Again, don't just send a certificate from a college ESOL course. It may be the right level. It's not an approved provider. You don't meet the requirements, and you will then lose the opportunity to vary that application and will stay on the 10-year route. So I hope that helps. So we have another question here. It says, my husband has come to the UK on the 10 years route. He has applied for his 2.5-year extension. It's been 4 months now. His visa card has not come through. Can you please let me know how long it will take to come? So up to 10 months at the moment is what the Home Office is advising. And you may have heard from other callers and queries that we've had today that those applications are taking forever longer. As the Home Office at the moment is advising up to 10 months, if your case is relatively straightforward, it meets the requirements, there are no particular complexities, then that's the point where you can challenge the delay. But again, the Home Office does say in its own guidance that there is no set time limit, so it doesn't give you a limit by which it will try and achieve to make a decision. It's just a case of we will try and make it within 10 months. It used to be we will try and make a decision within 6 months. They've clearly just extended that by 4 months. And then, you know, it may be as the delays get worse, which they are unfortunately, the Home Office may simply extend that indication of when a decision will be made and may say, you know, it'll now take longer to 12 months. But a very high proportion of cases are taken in excess of certainly 9 months, but more towards the 12-month mark, and some exceeding that as well. So you do need to be proactively chasing. And when I say proactively chasing, I don't mean harassing the Home Office, because that doesn't help. The Home Office has limited resources. And so what it's not helpful to do is to simply bombard them with regular correspondence asking for a decision, because then the time that they would spend working on your application is then diverted to answering queries. And you'll also find that the Home Office is simply not responding to any of these letters now anyway. So, you know, be sensible, do chase them, but don't harass or bombard the Home Office with repeated daily or weekly letters, because that's not really going to help you achieve the outcome you want to either. So I hope that helps and gives you some guidance in terms of your predicament at the moment. I have a question. I made an entry clearance application 6 months ago, but no reply from the Home Office. How long will it take? So again, any applications made from overseas are currently suspended. So they are taking a lot longer than they would. I mean, I don't know when this application was made. General timeframes for entry clearance applications are up to 12 weeks. You've already doubled that if you've been waiting for 6 months. And again, it's a case of either speaking to your legal representative or seeking legal advice to identify what the issues might be, what are the complexities in your case, what may be stopping the entry clearance officer making a decision in your application. Can you provide more evidence to speed that up, or is it just a case of prompting the Home Office that there is a decision outstanding and they can furnish that to you? So it's difficult to indicate, but as I say, it has you have exceeded the time they usually provide to make a decision by 50%. So it may be worth just checking why that is the case. As I mentioned, the Home Office has currently suspended most of the overseas applications, and that's to try and resolve the issues around the Ukraine refugees and visas from Ukraine nationals, either who are trying to flee or have already fled Ukraine. So entry clearance applications, that's applications made outside of the UK, could be visit visas, it could be spouse visas. Those are currently taking longer than they ordinarily would do. So again, be patient if you are in that category. So those are the immediate questions. I'll just go through to see if there's anything else that I can go through with you. And a lot of the questions this evening have been around UK immigration policy. Just be aware that there are quite significant changes coming in force in the next few months. There are price changes coming in the next couple of weeks. So, do again check those. If you are eligible to apply, you can apply up to 28 days before your UK visa expires. So if you currently have further leave to remain and you're due to apply for an extension within the next 28 days, then do so sooner rather than later, because there are fee changes, fee increases that will come into force at the beginning of April. And you can avoid that by making that application just before that date if you are eligible to do so. Please don't make the application if you're not eligible and you're not within that 28-day window, because that in itself can have other consequences and complications for you. So again, I think the general theme at the moment is the delay. And I did again provide some guidance for those who are asking again, what can you do to chase any delay or to address any delay with the Home Office? And I will focus on the Home Office because that's where all the queries, that's what all the queries are relating to. But with regards to your first step, contact the Home Office. Write to them. There's generally an address at the top of any letters that you've received. If you are legally represented, please speak to your legal representative. They may have already written to the Home Office. So that's the first thing you would need to do. If you get a response and it's not satisfactory, or you don't get the response at all, which seems to be quite common, your next step is to make a formal complaint. You can do that again on the Home Office website. There is a dedicated form that you fill in and send. There's an email address attached to that. And the Home Office indicates that it will deal with any complaints within 20 working days. Bear in mind, it's working days, not calendar days. And again, there's two themes emerging from that. Either they just don't bother responding, which is the most common, or the response is just lacking in any substance or assistance, so it's worthless. The next step is, and again, this can be done simultaneously when you're making the complaint, or you might want to do one after the other, but you contact your local MP. If your local MP can get some guidance from the Home Office and some time frames, that may be of assistance to you. And the absolute final step is to issue judicial review proceedings, but there are steps you need to take before you get to that point. And as I emphasized and repeatedly emphasized last week, there are huge cost implications in judicial review proceedings, so please do not attempt these by yourself without proper legal guidance and advice behind you, because you may not only end up paying your own legal costs, but also the cost of government legal lawyers, which I can assure you don't come cheap. So those are your steps with regards to the delay. We have now entered the final minute of our show this evening. I start to conclude by thanking everybody who has participated in the show, either by sending your questions through. I do apologize for the technical difficulties. I know that we had callers that were trying to get through, but the calls were dropping. I'm not entirely sure if the problem was on our side or theirs, but either way, we didn't get to speak to them. Inshallah, have a lovely break. Enjoy your Ramadan. May it be a blessed one for you. Have a lovely Eid. Remember me in your du'as. I will be back with Free Legal Advice show after Eid, and I will continue then to address your queries. In the meantime, may Allah bless you all. Assalamu alaikum wa rahmatullahi wa barakatuh.